Hello, my name is Barry Wood, and I'm the Assessment Division Director for the Indiana Department of Local Government Finance. Today we are going to talk about appeals. We will talk about general information about appeals and then talk about procedures for the appeal process. In 2017, the Indiana General Assembly passed legislation to change the appeal process. Previously, taxpayers could appeal their property taxes in two ways. One was by appealing subjective appeal issues, such as what is the value of my property. The other was objective appeal issues, in which they would contest things like, you assess me for a fireplace and I don't have a fireplace. Those two appeal procedures or processes were consolidated into a single proceeding so that now taxpayers can appeal their assessment on one form. The process begins at the local level and can eventually be appealed to the state only after being reviewed locally. The objective appeals was formerly used on Form 133, and that has been consolidated onto Form 130. A taxpayer still can file objective issues, however, it is on the second page of the appeal form. Subjective appeals, such as the value of the property, is filed on the first page of the appeal form. The appeal process begins with the taxpayer filing a notice of assessment or filing a notice of appeal with the local assessing official. A taxpayer may only request the review of the current year's assessed value. Following an informal conference with the local assessing official, the assessor will make a recommendation either denying or approving the appeal. If the appeal is denied, the appeal will be forwarded to the County Property Tax Assessment Board of Appeals. Each county has either a 3 or a 5-member Property Tax Assessment Board of Appeals. The members are appointed by the county commissioners and the county council. If the PTABOA, the Property Tax Assessment Board of Appeals, denies that taxpayer's appeal, the taxpayer has the right to file their appeal to the Indiana Board of Tax Review. After being heard by the Indiana Board of Tax Review, if the taxpayer still does not agree with their assessment or the determination, they may seek review with the Indiana Tax Court. As mentioned previously, objective appeals can still be appealed on the Form 130. Objective appeals issues may include the assessment was against the wrong person, the approval, denial, or omission of a deduction, credit, exemption, abatement, or tax cap, if there was a clerical, mathematical, or typographical mistake, if the description of the property is wrong, or the legality or constitutionality of a property tax or assessment. Objective assessment claims can be made up to 3 years in arrears. However, the taxpayer must request a refund along with that. So who can represent a taxpayer? Well, starts with themselves. They would be representing themselves pro se. They can use an attorney. They can use the services of a tax representative, or based on a change in the Indiana code, a relative of the owner, including a spouse, child, aunt, uncle, niece, nephew, grandparents, and children, can represent a taxpayer. In terms of who can file an appeal, it does not necessarily need to be the owner of record as of the assessment date. It could be a subsequent owner if that person is responsible for the taxes. However, the appeal still must be timely filed. The taxpayer has the right to file an appeal on an assessment. Those appeal dates are either June 15th, if a taxpayer receives a notice of assessment that was mailed before May 1st of the current assessment year, or if for whatever reason the assessing official did not send a notice of assessment, the taxpayer would have until June 15th of the following year to file an appeal. So in 2020, if the assessing official sent a notice of assessment by April 30th, the taxpayer would have had until June 15th, 2020 to file an appeal. If the assessor did not file or send a notice of assessment to the taxpayer would then have until June 15th of 2021 to file an appeal. The taxpayer must use the form prescribed by the Department of Local Government Finance, Form 130, and filing the appeal starts the process. It initiates the review, and it requires the assessing official to schedule a preliminary informal meeting with the taxpayer. In the informal hearing process, the taxpayer and the assessor will attempt to resolve as many issues as possible. After the hearing, the assessing official must forward the results to the Property Tax Assessment Board of Appeals in the auditor's office. If the Property Tax Assessment Board of Appeals receives a notice indicating that all the issues were resolved, the PTBOA votes to approve or deny the resolution. If the PTBOA accepts the agreed resolution, it issues a final determination adopting the resolution and vacating any scheduled hearing. If there is no agreement reached between the two parties, or the PTBOA does not hold a hearing within 180 days of the appeal being filed, the taxpayer then would have the right to file a notice to the Indiana Board of Tax Review. Taxpayer may request a continuance before the hearing. It must be scheduled at least 30 days in advance. If a taxpayer does not show at the hearing or request an extension of the hearing, a penalty of $50 may be assessed to the taxpayer for failure to appear. As indicated before, if the PTBOA does not hold a timely hearing within 180 days of the appeal being filed, the taxpayer may appeal directly to the Indiana Board of Tax Review. As a side note, the Indiana Board of Tax Review is a separate agency from the Indiana Department of Local Government Finance. At one point in time, the two agencies were known as the Indiana State Board of Tax Commissioners. However, those two departments have been created separately. During the appeal process, a taxpayer presents his or her evidence in regard to the disagreement. The assessing official must also present the basis for their assessment and refute the taxpayer's evidence. No appraisal is required by the taxpayer. If compared to the prior assessment, the assessed value increased by more than 5%, the assessor has the initial burden of proof to prove or show that the assessment is correct. The taxpayer still must file an appeal, even though the assessment may have increased by more than 5%. In regard to filing an appeal with the Indiana Board of Tax Review, the taxpayer may do so in respect to the assessment of their property, if an exemption was denied, if there were any tax deductions denied, or any tax credits denied. A taxpayer must file an appeal with the Indiana Board of Tax Review within 45 days from the Property Tax Assessment Board of Appeals order. At the Indiana Board of Tax Review level, an appraisal is not required by the taxpayer. The Indiana Board of Tax Review must hold the hearing within 9 months after the initial appeal is filed. Then they must issue a decision within 90 days after the hearing, unless an extension is ordered. A party may request a rehearing within 15 days of the final determination, and either party, the assessor or the taxpayer, may appeal to the Indiana Tax Court. Appealing to the Indiana Tax Court must be done within 45 days of the Indiana Board of Tax Review final determination, or at any time after the maximum time elapses for the IBTR the Indiana Board of Tax Review, to make a final determination. Either party may appeal the Indiana Tax Court determination to the Indiana Supreme Court. In initiating an appeal with the Indiana Supreme Court, the review by the Supreme Court is discretionary. If you have any questions, please reach us at the information shown on the screen. Thank you.